Welcome back to the Beyond Red and Blues Crucial Case Law Series. What do we got this week?
This week we have Graham versus Connor, a case decided in 1989 in which Graham, who was a diabetic, had some sort of insulin reaction while doing auto work in his home. A friend took him to a convenience store to purchase some orange juice, and he ran in, saw that there was a long line, and ran out relatively quick. An officer noticed that he was there an unusual quick amount of time and pulled him over about a half-mile away from the convenience store. Graham was still experiencing this insulin reaction and appeared that he was intoxicated, similar signs and symptoms as if he was under the influence of alcohol. Graham exited the vehicle and ran around the car several times before Officer Connor stopped him and sat him on the curb. Eventually, other officers arrived. Graham continued to resist even though he was handcuffed, and eventually sustained multiple injuries, including a broken foot as a result. Connor returned to the convenience store and determined that there was no crime and that he merely ran in and out. So Graham files charges and it goes through the initial courts, and the courts initially rule that the officers acted in good faith and did not appear to be malicious or sadistic. Graham argued, though, that the use of force was not objectively reasonable under the Fourth Amendment, and the initial appellate courts rejected the argument, still citing the good faith argument. This then goes up to the Supreme Court, and the Supreme Court unanimously rules that use of force should be now judged based on an objectively reasonable standard versus the good faith that it was initially looked at. And objectively reasonable is basically the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on scene rather than with 20/20 vision of hindsight. This is typically judged based on the totality of circumstances, and some of these things can include the severity of the crime, if there's any threat posed by the individual to the safety of the officers or other people, or whether or not the individual is trying to flee or resist at the time of arrest.
So, given that breakdown, let me give you a quick scenario. An officer commits a felony suspect to show their hands while they're behind his back. The suspect does not comply, but does not move either. Thinking the suspect might be reaching for a weapon, the officer tackles him to the ground and handcuffs him, dislocating the suspect's shoulder in the process. So, the question is, was the police officer's actions grounds for excessive force given the totality of the circumstances?
All right, and if there's any other case laws you guys are curious about, drop them down below.
All right, we'll see you guys next week.